The humid Baltimore summer of 1913 draped heavily over the row houses of Druid Hill Avenue, where a young Thurgood Marshall first opened his eyes to a world sharply divided by color. The neighborhood, though predominantly African American, was a patchwork of striving families, church steeples, and the constant, unspoken rules of segregation. From his bedroom window, he could see the well-kept streets of his own community, but just a few blocks away lay the invisible boundaries that barred him from certain parks, schools, and lunch counters. His father, William, worked as a railroad porter and later as a steward at an all-white country club, a job that exposed him daily to the casual cruelties of Jim Crow. At the dinner table, William would recount stories of humiliation with a sharp wit, teaching young Thurgood that the law, though twisted by prejudice, was still a tool to be mastered. His mother, Norma, a kindergarten teacher, instilled in him a love for learning and a quiet resilience, often taking him to the colored branch of the public library, a modest building where the books were worn but the dreams were boundless. The light filtering through the dusty windows of that library seemed to carry a promise, a soft illumination on the pages that spoke of a world beyond segregation's grip. Marshall's childhood was not one of abject poverty, but of constant vigilance. He attended the all-black Henry Highland Garnet School, a sturdy brick building where dedicated teachers did their best with outdated textbooks handed down from white schools. The walls were adorned with portraits of Frederick Douglass and Booker T. Washington, silent mentors urging perseverance. Walking home, he would pass by the grand, columned edifice of the white school, its playground filled with new equipment, and feel the sting of inequality not as an abstract concept, but as a daily reality. One afternoon, while shopping with his mother in a downtown department store, he was roughly turned away from a water fountain labeled "Whites Only." The cold metal of the sign, the indifferent glance of the store clerk, and his mother's dignified silence as she led him away burned into his memory. That evening, the setting sun cast long, somber shadows across their parlor as his father explained that such indignities were not a reflection of his worth, but a flaw in the nation's legal fabric. These moments, small yet piercing, were the kindling for a fire that would later consume segregation's legal foundations. At the age of 16, Marshall entered Lincoln University in Pennsylvania, a historically black college nestled among rolling hills and ancient oaks. The campus, with its Gothic Revival buildings and tranquil quadrangles, was a sanctuary from the overt segregation of Baltimore, yet it was not immune to the wider world's tensions. Here, he encountered a vibrant community of scholars and activists, where debates about race, justice, and the Constitution echoed through the dormitories late into the night. The library, with its high-vaulted ceilings and rows of leather-bound volumes, became his refuge. He spent countless hours poring over legal texts and philosophy, the scratch of his pen on paper the only sound in the quiet alcoves. It was at Lincoln that he first grasped the power of reasoned argument, sharpening his wit in the student debating society. The autumn light, golden and thick, would stream through the stained-glass windows of the chapel, casting prismatic colors on the floor as he sat contemplating the moral imperative of equality. Yet, even in this haven, the harsh reality of racism intruded. On trips to nearby towns, he and his classmates were denied service at restaurants, a reminder that their intellectual pursuits existed in a world that saw them as second-class citizens. A pivotal experience during his college years occurred on a train ride back to Baltimore. Despite holding a first-class ticket, Marshall was forced to move to the segregated car, a cramped and smoky space behind the locomotive. As the train chugged through the Maryland countryside, the contrast between the plush seats he had left behind and the hard benches of the Jim Crow car was a visceral lesson in legalized humiliation. The rhythmic clatter of the wheels on the tracks seemed to beat out a question. How could a nation founded on liberty tolerate such blatant injustice? He stared out the window at the passing farmlands, the golden wheat fields and distant barns bathed in the soft light of late afternoon, and felt a deepening resolve. This was not merely a personal insult, it was a systemic failure that demanded a systemic response. The conductor's gruff voice, The averted eyes of white passengers and the resigned expressions of his fellow black travelers all seared into his consciousness, transforming his youthful anger into a focused determination to wield the law as a weapon. After graduating from Lincoln in 1930, Marshall returned to Baltimore, his desire to fight segregation burning brighter than ever. He applied to the University of Maryland Law School, a stately institution with ivy-covered walls just miles from his home, but was rejected solely because of his race. The rejection letter, a crisp, formal document, was a stark affirmation of the barriers he sought to dismantle. Instead, he traveled to Washington, D.C. to attend Howard University School of Law, a decision that would alter the course of American history. The train journey to the Capitol mirrored so many others, the familiar shift to the colored car as they crossed the Potomac. But this time, his mind was not on the indignity, but on the opportunity ahead. The city's monuments, gleaming white in the morning sun, stood as ironic symbols of a freedom not yet fully realized. As he walked up the steps of Howard's Law Building, a handsome red brick structure with white columns, he felt the weight of his ancestors' hopes and the quiet, steady pulse of a coming legal revolution. The shadows of the columns fell in sharp lines, a metaphor for the stark choices ahead, but Marshall stepped into the light of the doorway, ready to learn how to make the Constitution fulfill its promise. Imagine a crisp autumn morning in Washington, D.C., in 1930. The air carries the scent of fallen leaves and the distant hum of a city awakening. A tall, determined young man walks through the iron gates of Howard University, his footsteps echoing on the cobblestone path. This is Thurgood Marshall, fresh from Lincoln University, carrying not just a worn leather satchel of books, but the weight of his father's words. If anyone calls you a nigger, you not only got my permission to fight him, you got my orders. The Howard University School of Law building stands before him, a modest yet dignified structure of red brick and white columns, its windows catching the soft morning light. Inside, the halls are quiet, lined with portraits of legal minds, and the air smells of old paper and floor wax. Marshall pauses, adjusting his tie, aware that this place will either break him or forge him into something formidable. At Howard, Marshall encounters the man who will reshape his destiny, Charles Hamilton Houston, the visionary dean and NAACP legal architect. Houston's classroom is a revelation, a space where the Constitution is not merely a document to be memorized, but a living weapon to be wielded. Houston, with his piercing gaze and meticulous suits, paces before a chalkboard covered in case citations, his voice steady as he declares, a lawyer is either a social engineer or a parasite on society. For Marshall, this is a baptism into a new way of thinking. The curriculum is grueling, designed to produce not just competent attorneys, but crusaders for justice. Days begin before sunrise with Socratic drills, and nights stretch into the early hours as Marshall pores over torts and property law by the dim glow of a desk lamp. The library becomes his sanctuary, its towering shelves of leather-bound volumes casting long shadows across the polished floors. He learns to dissect precedents, to find the cracks in the edifice of Jim Crow, and to build arguments that could sway the highest courts. Houston's mantra, that segregation must be attacked through the Equal Protection Clause, becomes Marshall's guiding star. Graduating first in his class in 1933, Marshall steps into a world still shackled by segregation. He opens a small law practice in Baltimore, a city of brick row houses and bustling harbors, but his true calling lies with the NAACP. His early work is unglamorous, often conducted in cramped offices with peeling paint and the constant clatter of typewriters. He travels through the Maryland countryside, past fields of tobacco and quiet towns, to meet with black teachers who are paid a fraction of their white counterparts. In county courthouses with creaking wooden benches and ceiling fans stirring the humid air, Marshall argues that this disparity violates the separate but equal doctrine. His first major victory comes in 1936 with Murray v. Pearson, where he successfully sues to integrate the University of Maryland Law School, the very institution that rejected him because of his race. The courtroom, with its high windows and somber mahogany paneling, becomes a stage where Marshall's voice rises and falls with controlled passion, his arguments weaving together legal precision and moral clarity. But it is the teacher's salary cases that hone his strategic mind. In a one-room schoolhouse in rural Virginia, the floorboards worn smooth by generations of feet, Marshall sits across from a black educator who has taught for decades with meager resources. The chalkboard behind her is cracked, the textbooks tattered hand-me-downs from white schools. Marshall listens intently, his pen scratching notes on a yellow legal pad, as she describes her daily reality, rising before dawn to walk miles to school, teaching children of all ages in a single room, and returning home to grade papers by kerosene lamp. He sees not just a case, but a pattern, a systematic devaluation of Black life that the law could and must remedy. In court, he presents evidence with the precision of a surgeon, pay stubs, school budgets, and testimony that paints a damning picture of inequality. The victories that follow, in counties across Maryland and Virginia, are incremental but profound. They establish a blueprint for challenging segregation not with fiery rhetoric alone, but with the cold, hard facts of constitutional violation. These early triumphs reveal Marshall's evolving philosophy. The law is a tool, and like any tool, its power depends on the skill of the user. He learns to balance idealism with pragmatism, to understand that lasting change comes not from a single dramatic ruling, but from a relentless accumulation of precedents. In the quiet of his office, surrounded by stacks of legal briefs and the faint smell of coffee, he maps out a long-term strategy with Houston and other NAACP lawyers. They speak of chipping away at Plessy versus Ferguson, of building a ladder of cases that would eventually reach the Supreme Court. Marshall's laughter, deep and infectious, often breaks the tension during late-night sessions, but his focus never wavers. He becomes known for his meticulous preparation, his ability to anticipate opposing arguments, and his unshakable belief that the Constitution, properly interpreted, was on their side. Yet this period also reveals a limitation in his approach, one that would shadow his career. Marshall's faith in the legal system is almost absolute. He believes that rational argument and factual evidence can overcome deeply entrenched prejudice. This legal centrism, while effective in courtrooms, sometimes overlooks the extra-legal realities of intimidation, violence, and economic reprisal that Black communities face daily. His strategy relies on elite legal channels, which can feel distant from the grassroots activism bubbling up in churches and street corners. Still, it is this very dedication to the rule of law that makes his work so enduring. He is not merely fighting individual injustices, but constructing a framework that future generations can use. The lessons from these years are clear. Meaningful change requires patience, rigorous preparation, and an unwavering commitment to principle, even when the path is slow and the victory small. As the 1930s draw to a close, Marshall stands on the threshold of a larger stage. The teacher's salary cases have given him confidence and a proven methodology. He understands now that segregation is not an immutable force, but a legal construct that can be dismantled, brick by brick. Walking through the streets of Baltimore, past the markets and churches of his youth, he carries with him the voices of the teachers, the students, and the families he has served. The Constitution, once a distant ideal, has become a living companion in his daily work. And in the quiet moments, perhaps as he watches the sunset paint the city in shades of gold and amber, he allows himself a rare moment of reflection, knowing that the strategies forged in these modest courtrooms will soon be tested on the national stage, in a case that will bear the name of a little girl from Topeka, Kansas. In the quiet hours before dawn, the law library at Howard University held a stillness that Thurgood Marshall had come to know intimately. The warm glow of a desk lamp illuminated stacks of legal briefs and dog-eared casebooks, casting long shadows across the polished wooden tables. Here, in this sanctuary of legal thought, Marshall would sit alone, tracing with his finger the words of the 14th Amendment, his mind already racing through the arguments he would one day present to the highest court in the land. The scent of old paper and leather bindings filled the air, a constant companion during those early years when the road ahead seemed both clear in purpose and impossibly long. Outside, the streets of Washington, D.C. were beginning to stir, but inside this room, a different kind of awakening was taking shape, one that would fundamentally alter the fabric of American society. As chief counsel for the NAACP Legal Defense Fund, Marshall understood that dismantling segregation required more than moral outrage. It demanded a patient, step-by-step legal strategy. He and his mentor, Charles Hamilton Houston, had long recognized that a direct assault on the separate but equal doctrine established by Plessy v. Ferguson would likely fail if brought prematurely. Instead, they chose to first challenge inequality within the segregated system itself. Marshall traveled tirelessly across the South, often driving through the night to avoid the dangers of sundown towns, his worn briefcase filled with affidavits and evidence. In small courthouses where the air was thick with humidity and hostility, he argued cases demanding equal pay for Black teachers, equal facilities for Black students, and equal access to graduate programs. Each victory, though limited in scope, was a carefully placed brick in a foundation that would eventually support a much larger structure of constitutional change. The turning point in this incremental campaign came with a series of cases targeting the inherent inequality of segregated graduate and professional education. In 1946, Marshall took on the case of Heman Marion Sweat, a Black postal worker denied admission to the University of Texas Law School solely because of his race. Standing in the courtroom, Marshall did not merely argue that the hastily created basement law school for Blacks was unequal in tangible resources. He went further, asserting that segregation itself inflicted a psychological harm that could never be remedied by separate facilities. The state's makeshift law school, he noted, had no library, no faculty, and no tradition. It lacked the intangible qualities that make an education meaningful. The Supreme Court's decision in Sweat v. Painter in 1950 ordered Sweat's admission, acknowledging for the first time that intangible factors like reputation and alumni networks were part of the educational experience. It was a crack in the edifice of Plessy, and Marshall knew it. That same year, Marshall pressed the advantage with McLaurin v. Oklahoma State Regents, a case involving a Black doctoral student who was admitted to the University of Oklahoma but forced to sit in an anteroom separate from white classmates. The image of George McLaurin isolated in a chair marked colored, while his peers sat together in the main classroom, was a stark illustration of the stigma of segregation. In his argument, Marshall emphasized that such treatment impaired McLaurin's ability to learn and exchange ideas, thereby violating the Equal Protection Clause. The court agreed, ruling that the restrictions imposed on McLaurin were unconstitutional. These graduate school cases were essential stepping stones. They established that even when physical facilities were made nominally equal, segregation still produced inequality. The legal logic was tightening around Plessy, and Marshall was methodically preparing the final, decisive blow. By the early 1950s, the NAACP's strategy had matured. Marshall and his team began consolidating multiple school segregation cases from Kansas, South Carolina, Virginia, and Delaware into one coordinated challenge. They knew that a direct attack on elementary and secondary school segregation would face fierce resistance, but the groundwork had been laid. In their briefs, they drew upon the Sweat and McLaurin precedents to argue that segregation in public schools was inherently unequal. Crucially, they introduced social science evidence, including the now famous doll studies by psychologists Kenneth and Mamie Clark, which demonstrated that segregation damaged Black children's self-esteem. This was a bold move, blending law with social science to show that the harm of segregation was not just material, but psychological. The stage was set for a confrontation that would define Marshall's career and reshape the nation. Throughout this long campaign, Marshall's daily life was a testament to perseverance. He worked out of a modest office in New York, its walls lined with law books and maps of the South marked with pins indicating active cases. The work was grueling and often dangerous. He faced threats, hostile judges, and the constant weight of representing millions who had no voice. Yet he maintained a calm, almost jovial demeanor, often easing tension with a well-timed joke. His colleagues marveled at his ability to switch from fierce courtroom advocacy to warm camaraderie over a late-night meal at a segregated diner, where they would strategize over coffee and cornbread. These moments of ordinary life, the clinking of spoons, the murmur of tired conversation, were the quiet backdrop to an extraordinary legal revolution. As the cases were consolidated under the name Brown v. Board of Education of Topeka, Marshall stood at the threshold of history. The road had been long, paved with countless small victories and careful legal reasoning. Now, the question was no longer whether separate could be equal, but whether segregation itself was a violation of the Constitution. In the coming months, Marshall would pour all his energy into preparing for oral arguments, refining his points, anticipating every counterargument. The library lights would burn late into the night once more, as they had years before, but now the stakes were immeasurably higher. The strategy had been meticulous, the precedent set. All that remained was to convince 9 justices that the promise of equal protection must finally be made real for every child, regardless of the color of their skin. On a crisp December morning in 1952, the United States Supreme Court building stood as a temple of justice, its marble columns glowing softly in the winter light. Inside, the courtroom was packed with spectators who had waited in line for hours, their breath visible in the cold air before they entered the hushed chamber. The mahogany benches gleamed, and the red carpet muffled footsteps as lawyers, journalists, and ordinary citizens took their places. At the counsel table, Thurgood Marshall adjusted his notes, his fingers steady despite the weight of the moment. He looked up at the 9 justices seated behind the elevated bench, their black robes stark against the white marble walls. The quiet hum of anticipation was broken only by the sound of a turning page or a whispered comment. This was the culmination of decades of legal strategy, and Marshall was about to deliver the argument that would challenge the very foundation of racial segregation in America. Marshall's oratory that day was not fiery but measured, a calm and relentless logic that drew the justices into the heart of the constitutional question. He began by dismantling the myth that separate facilities could ever be truly equal, citing the tangible inequalities in the schools at issue, the crumbling buildings, outdated textbooks, and lack of basic resources for Black children. But he quickly moved beyond material disparities, emphasizing the psychological harm documented by the Clark-Stahl studies. He spoke of the feeling of inferiority that segregation instilled in Black children, a wound that no amount of equal funding could heal. His voice, deep and resonant, filled the chamber without straining, and he looked each justice in the eye, appealing not just to legal precedent, but to their sense of fundamental fairness. The arguments stretched over several days, and in the months that followed, the case was re-argued as the court grappled with the profound implications of overturning Plessy. Behind the scenes, the justices' deliberations were complex and fraught. Chief Justice Earl Warren, who had joined the court after the initial arguments, worked tirelessly to achieve a unanimous decision. He understood that a divided ruling would invite massive resistance and undermine the court's authority. In private conferences and circulated memos, the justices debated the historical intent of the 14th Amendment and the proper role of the judiciary in social reform. Some were initially hesitant, concerned about judicial overreach and the upheaval that would follow. But Warren's patient diplomacy, combined with the compelling record built by Marshall and his team, gradually swayed the holdouts. The final opinion, drafted by Warren himself, was deliberately short and accessible, meant to be read by ordinary citizens, not just lawyers. It avoided accusatory language and instead framed segregation as a moral and practical failure that had no place in a nation committed to equality. On May 17, 1954, the court convened to deliver its unanimous ruling. The chamber was again crowded, the air thick with tension. Chief Justice Warren read the opinion in a clear, steady voice. We conclude that in the field of public education the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. The words hung in the air for a moment, and then a quiet ripple of emotion passed through the room. Marshall, seated in the audience, felt a surge of relief and vindication. Outside, the news spread rapidly. In Black communities across the country, people gathered in churches and living rooms, weeping and praying with joy. The New York Times called it a day of history, and the decision was front-page news worldwide. For Marshall, it was the realization of a dream that had begun in the segregated streets of Baltimore, a testament to the power of the law as an instrument of justice. The social impact of Brown was immediate and far-reaching, but it also ignited a fierce backlash. In the South, massive resistance campaigns took shape, with state legislatures passing laws to close public schools rather than integrate them. White citizens' councils formed, and some communities saw a resurgence of Ku Klux Klan activity. The decision did not end segregation overnight. In many places, it took years of further litigation and federal intervention to enforce. Yet, the ruling provided a moral and legal foundation for the civil rights movement that would follow. It inspired activists to challenge other forms of discrimination, from bus boycotts to sit-ins, and it established a precedent that the Constitution's guarantee of equal protection applied to all citizens, not just in theory but in practice. Marshall understood that the struggle was far from over, but he also knew that the court had given them a powerful new tool. In the aftermath, Marshall returned to his work with the NAACP, his days still filled with strategy sessions and court appearances. He would often walk the halls of the Supreme Court building, now as a visitor rather than an advocate, reflecting on the journey. The marble corridors, with their echoes of past decisions, reminded him that the law was a living thing, shaped by the courage and vision of those who fought for justice. He thought of the countless plaintiffs who had risked their livelihoods and safety to sign their names to the case, of the parents who simply wanted their children to have a fair chance. Their faces stayed with him, a quiet motivation for the battles ahead. In the evenings, he might sit on a park bench overlooking the Capitol, the dome illuminated against the night sky, and allow himself a rare moment of peace, knowing that he had helped bend the arc of history. The Brown decision remains a landmark in American jurisprudence, a moment when the Supreme Court unequivocally affirmed that equality cannot exist under a system of separation. Thurgood Marshall's role in that victory was indispensable. His strategic brilliance and unwavering moral clarity turned a legal campaign into a national transformation. Yet, the decision also revealed the limits of judicial power. Desegregation proceeded slowly, and de facto segregation persists in many forms to this day. Marshall himself would later acknowledge that the court could declare principles, but it could not change hearts. Nevertheless, Brown v. Board of Education endures as a beacon, a reminder that the Constitution is a charter of liberty capable of redeeming its promises. For those who listened to Marshall's arguments and witnessed the unanimous ruling, it was a testament to the idea that, in a just society, the law must protect the dignity of every individual. Imagine a crisp autumn morning in Washington, D.C., 1965. The marble corridors of the Justice Department gleam under soft fluorescent light, and the air carries the quiet hum of legal scholarship. Thurgood Marshall, now in his late 50s, walks these halls not as a civil rights attorney battling from the outside, but as the Solicitor General of the United States, the first African American to hold the post. His stride is measured, his presence commanding yet approachable. In his office, shelves sag under the weight of law books, and a window overlooks the Capitol's tree-lined streets. This is a man who has spent decades fighting segregation in courtrooms across the South, and now he represents the federal government before the very Supreme Court he once petitioned for justice. The transition is profound, from advocate to institutional insider, yet his commitment to the Constitution as a living shield for the vulnerable remains unshaken. He argues cases with the same moral clarity, but now his voice carries the authority of the executive branch, shaping legal doctrine on a national scale. Marshall's tenure as Solicitor General, though brief, only 2 years, was marked by his characteristic blend of pragmatism and principle. He approached each case not merely as a legal puzzle, but as a human story, often staying late into the evening, the glow of his desk lamp illuminating briefs that sought to expand civil rights protections. One of his significant contributions was defending the Voting Rights Act of 1965, a landmark law he had long championed. Standing before the justices in the solemn courtroom, with its red velvet drapes and towering columns, he argued with the same passion he had displayed in Brown v. Board of Education. His voice, deep and resonant, filled the chamber as he explained how the act was essential to dismantle the entrenched barriers that kept Black citizens from the ballot box. The justices listened intently, some leaning forward, aware they were witnessing history. Marshall's arguments helped secure the act's constitutionality, reinforcing the federal government's role in protecting voting rights, a cornerstone of democratic equality. Then, in 1967, President Lyndon V. Johnson made a decision that would etch Marshall's name into the annals of judicial history. On a warm June day, Johnson nominated Marshall to the Supreme Court of the United States, declaring it the right thing to do, the right time to do it, the right man and the right place. The announcement sent ripples through the nation. For many Black Americans, it was a moment of profound hope, a symbol that the highest court would finally reflect the diversity of the nation. The Senate confirmation hearings, however, were grueling. Southern senators, still smarting from the Civil Rights Revolution, grilled Marshall on his judicial philosophy and past activism. In the hearing room, under bright television lights, Marshall sat composed, his hands folded, answering each question with a calm that belied the magnitude of the moment. He was confirmed by a vote of 69-11, and on October 2, 1967, he took his seat as the first African-American Supreme Court justice. The courtroom, with its mahogany bench and hushed reverence, gained a new presence, one that would champion the rights of the accused, the poor, and the marginalized for nearly a quarter century. On the court, Marshall became known as a staunch liberal voice, often writing powerful dissents that spoke directly to the conscience of the nation. His chambers were a warm, cluttered space filled with memorabilia from his civil rights days, and he frequently welcomed young lawyers and law clerks, mentoring them with stories and wit. One of his most notable opinions came in the realm of affirmative action. In the 1978 case Regents of the University of California v. Bakke, the court struck down a rigid quota system, but allowed race to be considered in admissions. Marshall, writing separately, delivered a searing concurrence that drew on his own experiences. He argued that for centuries, Black Americans had been systematically excluded from opportunity, and race-conscious remedies were essential to level the playing field. His words were not just legal reasoning but a moral plea. It is more than a little ironic that, after several hundred years of class-based discrimination against Negroes, the court is unwilling to hold that a class-based remedy for that discrimination is permissible. This opinion remains a touchstone in the ongoing debate over equality and merit. Marshall's unwavering opposition to the death penalty was another hallmark of his jurisprudence. He believed capital punishment was cruel and unusual, disproportionately applied to the poor and people of color. In case after case, he dissented from decisions upholding death sentences, often writing alone or with just one colleague. In the quiet of his office, late at night, he would pen these dissents with a sense of moral urgency, the scratch of his pen a lonely protest. His most comprehensive statement came in the 1972 case Furman v. Georgia, where the court temporarily halted capital punishment. Marshall wrote that the death penalty was unconstitutional because it served no legitimate penal purpose and was imposed arbitrarily. Though the court later reinstated capital punishment, Marshall never relented, and his dissents became a moral compass for abolitionists. He saw the law not as a static set of rules, but as a tool for human dignity, and his opinions reflected a deep empathy for those society had discarded. However, Marshall's tenure was not without criticism. As the court grew more conservative in the 1970s and 1980s, his judicial philosophy was increasingly seen as a form of activism that overstepped the judiciary's role. Detractors argued that he relied more on personal conviction than on the original meaning of the Constitution, and that his decisions on issues like affirmative action and criminal procedure expanded rights beyond what the framers intended. Even some allies felt his approach sometimes lacked the rigorous textualism that could sway moderate justices. Marshall himself was unapologetic, famously stating, "You do what you think is right and let the law catch up." This tension between his vision of a living constitution and the strict constructionism of his opponents highlighted a fundamental debate about the role of the Supreme Court in American democracy. It is a debate that continues to shape the judiciary today, and Marshall's legacy is central to it. By the time he retired in 1991, the marble pillars of the Supreme Court had witnessed the arc of his extraordinary journey, from a young lawyer fighting Jim Crow to a justice who helped redefine the meaning of equality under law. His years on the bench were marked by a relentless defense of individual rights, even when he stood in the minority. He left behind a body of opinions that continue to inspire lawyers and activists, and his life story remains a testament to the power of perseverance. As the sun set on his judicial career, one could imagine him looking out over the capital city, reflecting on a nation still grappling with its promise of justice for all. His work was not finished, but the foundation he laid would endure. Picture a quiet evening in the early 1990s, in a modest home in Washington, D.C. The light is soft, filtering through lace curtains, casting gentle shadows on the walls adorned with photographs of a life fully lived. Thurgood Marshall, now retired from the Supreme Court, sits in a worn armchair, a book resting in his lap. Outside, the city hums with the usual rhythms, but inside there is a stillness, a space for reflection. His body, once so vigorous in courtrooms and marches, has slowed, but his mind remains sharp. He thinks back to the segregated Baltimore of his youth, the long train rides through the South to defend black clients, the elation of the Brown decision, and the weight of his judicial robes. This is a man who used the law not as a shield for the powerful, but as a sword for the powerless, and in these twilight years, he contemplates the distance traveled and the road still ahead. The room is filled with the scent of old paper and the quiet ticking of a clock, marking time that now seems both precious and heavy with memory. Marshall's retirement in 1991 was a moment of national reckoning. After 24 years on the highest court, he stepped down citing age and health, leaving a vacancy that would shift the court's ideological balance. His departure prompted an outpouring of tributes, but also a sober assessment of his impact. In interviews, Marshall spoke candidly about the ongoing struggle for equality, warning that the gains of the civil rights movement were fragile. He often quoted the old spiritual, "We ain't what we ought to be, we ain't what we want to be, we ain't what we're going to be, but thank God we ain't what we was." His voice, though weakened, carried the same moral clarity. He urged young people to continue the fight, not with violence, but with the tools of democracy, voting, education, and the law. In public appearances, he would sit on stage, his presence alone a lesson in resilience, and remind audiences that the Constitution was a promissory note that must be honored for all. His legacy is etched not only in legal opinions, but in the very fabric of American society. The desegregation of schools, the protection of voting rights, the expansion of due process, these are monuments to his life's work. Yet, Marshall himself would caution against complacency. He understood that laws could be changed, and that progress required constant vigilance. In his later years, he often visited law schools, where students gathered to hear him speak. In lecture halls filled with afternoon light, he would share stories of his cases, his laughter booming one moment and his voice dropping to a serious whisper the next. He emphasized the importance of constructive engagement with the legal system, using its rules and procedures to achieve justice, rather than resorting to despair. His own career was a masterclass in this approach, patient, strategic, and always grounded in the belief that the system could be made to work for everyone. Marshall's constructive use of the legal system offers enduring lessons. He demonstrated that lasting change often comes through meticulous preparation and unwavering commitment. As a young lawyer, he would spend countless hours in dusty libraries, researching precedents and crafting arguments that would dismantle segregation piece by piece. This methodical approach, learned under Charles Hamilton Houston, became the blueprint for the civil rights legal strategy. Today, lawyers and activists continue to draw inspiration from his example, recognizing that progress is rarely swift, but is possible through persistence. His life teaches that the law is not an abstract set of principles, but a living instrument that can be shaped by those with the courage to wield it. In a world still grappling with inequality, Marshall's legacy is a reminder that the courtroom can be a crucible for social transformation. However, a neutral examination of his legacy must acknowledge the debates that surround it. As the Supreme Court moved rightward in the decades after his retirement, many of his decisions and dissents were marginalized or overturned. Critics argue that his judicial activism, his willingness to interpret the Constitution broadly to achieve progressive outcomes, set a precedent that undermined judicial restraint. They point to cases like his dissent in San Antonio Independent School District versus Rodriguez, where he argued for a constitutional right to equal education funding, as an example of overreach. Even some supporters concede that his sweeping moral vision sometimes lacked the textual grounding that could have made his arguments more durable. This tension between his expansive reading of the Constitution and the strict constructionism of his successors reflects a fundamental divide in American jurisprudence. It is a divide that ensures Marshall remains a contested figure, celebrated by many as a hero and critiqued by others as a symbol of judicial overreach. Marshall passed away on January 24, 1993, at the age of 84. His funeral at the Washington National Cathedral was a solemn affair, with dignitaries and ordinary citizens alike paying their respects. The stone arches of the cathedral rose high above, light streaming through stained glass windows, casting colorful patterns on the congregation. His flag-draped casket lay in state, a testament to a life of service. In the quiet of that sacred space, there was a sense of both loss and gratitude. He had lived to see the legal edifice of segregation crumble, but he also knew that the work of building a just society was never complete. His epitaph might be found in his own words: "None of us got where we are solely by pulling ourselves up by our bootstraps. We got here because somebody, a parent, a teacher, an Ivy League crony, or a few nuns, bent down and helped us pick up our boots." Today, Thurgood Marshall's legacy endures in the countless lives he touched and the legal principles he championed. His bronze statue stands in downtown Baltimore, near the courthouse where he once argued cases, a silent sentinel of justice. Students walk past it daily, some pausing to read the inscription, others simply glancing up as they hurry by. The statue captures him in mid-stride, as if still moving forward, still fighting. His life story is taught in schools, his opinions studied in law schools, and his name invoked in debates over civil rights. The lessons he imparted, perseverance, strategic thinking, and a deep faith in the rule of law, remain relevant. As the sun sets on another day in America, his legacy reminds us that the arc of the moral universe, while long, bends only when people like Thurgood Marshall dedicate their lives to bending it.